Everyone, my name is Ashley Kreider, and I coordinate our technical assistance to the MacArthur Safety and Justice Challenge. I know most or many of you are visiting us via that source, so welcome, and welcome to folks that may have been forwarded a webinar and you're not sure how it got here. But we have been at PRA providing technical assistance to the MacArthur SJC since 2016 and work with sites around the country in their efforts to decriminalize mental illness and reduce inappropriate incarceration of folks with mental health and substance use needs. So as part of that technical assistance, we work with a smaller group of 17 sites called the Impact Network, and that group has been active for about a year and a half. And part of our work with those sites is to provide topical technical assistance virtually. So we've been doing that across a variety of topics, and this is one of the webinars in that series. Although given the heaviness, I guess, and the applicability of this topic, we decided to open it up to a much wider audience. So again, welcome. And you'll be hearing from all of staff from PRA from this one, and we'll also feature some information coming from sites that we've worked with around the country. So I just want to do a quick tech overview. I think probably most of us are familiar with Zoom by now, but we wanted to have this in a meeting format to allow some interaction. So please just watch the mute button if that becomes a factor, and use the chat box as much as you want to. We'll be monitoring that, so feel free to put questions in that space, and we'll also have plenty of time to unmute and ask questions verbally at the end of today's presentations. There are also a couple of different view options, so if you play with that, you should be able to have some tailored views to speakers and the slides themselves. Okay, so by way of introductions, I will kick it off here and then turn it over to our first presenter. So first we're going to hear from Dr. Shannon Bader, a senior project associate at PRA, and she will talk about some competency sort of 101 issues, as well as provide an overview of the competency system. And then we will turn it over to Dr. Lisa Callahan, also a senior project associate, and she will highlight competency issues across various intercepts within the Sequential Intercept Model, and also some specific examples from our work with Washington State in particular. And then finally, she will talk about various models of competency restoration and what that can look like from site to site. And then finally, we'll hear from PRA's president, Dr. Sarah Desmarais, and she will talk about the research perspective. So what do we know about competency? What don't we know? And how can that apply to the work that you all are doing with your communities? As I said, we'll have time at the end for verbal Q&A, but feel free to chat your questions along the way and we'll track those. With that said, I will turn it over to our first presenter, Dr. Bader.
Hi, everybody. Glad you're here. We were saying earlier that this topic is one close to all of our hearts, that we could probably talk for an hour on each one of these individual slides. So we are going to try to give you just a quick overview. Sorry, I'm going too fast. So some of you may be familiar with competency to stand trial, and some of you may not be. So I'm just going to give a brief sort of sense of what this topic really means. And I want to start with where it all started here in the United States. So back in 1960, the United States Supreme Court made a decision in Dusky v. US that really just established and created the definition of competency in the United States. Now, what strikes me is that 1960 wasn't that long ago. A lot of our legal background is based in much, much older law, but 1960 is recent. And that's notable, I think, because actually the concept of competency for trial has been around since Old English law. Back in the 1600s, there's writing about the need for people to be present in court, and not just physically present, but mentally present. And in the 1600s, they used the term mute by visitation of God, which meant that someone was deaf or mute, nonverbal, or psychiatrically ill. But it took from the 1600s all the way until 1960 for us to have this definition that we could rely on. The bottom line for Dusky and all descriptions of competency is that the person has to be capable of participating, meaningfully participate in their own case, their own criminal justice system. So the Dusky criteria, as we talk about them as a psychologist, I talk about them as the Dusky criteria, is laid out in the court decision, and it has three major features. First is the word factual, and then there's also a discussion of a rational understanding, and then the ability to consult with an attorney. I just want to pause here too to talk more about this timing. So again, I think of 1960 is very, very recent. This is an important piece of our system that's relatively recent, but competency is still evolving. So it wasn't until even later than this that competency to stand trial was applied to juveniles in a case called In re Galt. And then actually just in 2012, competency was applied to immigration proceedings. So competency as a legal field has been continuing to evolve and change throughout the last generation. So when I say that there's three pieces, oh, I went too far again. There's three pieces of competency to stand trial: the rational piece, factual piece, and ability to consult with your attorney. Let's just talk a little bit about what that means. So factual is the easiest part, I think. So does the person know what their charges are? Do they know what they're being accused of? Do they understand if it's serious or not serious? Maybe the person doesn't know the words felony or misdemeanor, but do they understand what could happen to them if they're found guilty? Do they know what probation means? Do they know what a prison term means? The bar for this is really low. You're not expected to be a little lawyer. You're not expected to know everything you have to know ever. Generally, I find that people who've watched some People's Court and a couple episodes of Law and Order know quite a bit. Also, I'm also shocked routinely about how few people know what a prosecutor does. We don't teach a lot about the criminal legal system in our public school system, and unless you've gone through it, there's not a lot of other options besides media to really show people what it involves. So the average person's factual understanding about the court system can really vary. But what's important is that it's not what you know necessarily, but can you learn it? So factual understanding is just the basics. Again, who's in the courtroom? What does a judge do? But if you don't know it, it doesn't mean you're incompetent. Ignorance is not incompetence. You have to be able to learn it and understand it for later. The rational piece is a little bit more nuanced. Rational understanding is really this sense of, does the person know what the evidence is against them? Do they really know how strong or weak that evidence is? Can they think about defense strategies for how to approach that evidence? And this is a big part of it. Can they actually make decisions about their legal future? Can they make thoughtful, meaningful decisions about what they should do? This is everything from taking a plea bargain to going to trial, choosing a jury versus a judge to make a decision if they go to trial. There are a lot, which plea to use right at the start, lots and lots of legal decisions that the person needs to consider and make. My favorite example potentially of poor rational understanding is a gentleman who was on video of stealing some pants. It shows him on video taking a whole stack of jeans and then walking out without paying. So we talk about that. He's able to say, oh yeah, I'm on video. They've got me. I looked right at the camera. They have my face. They know it's me. And he said, but I don't think I'm going to be found guilty. I don't think that's enough. And that doesn't really make sense, right? Because it is strong evidence. That actually is really probably some of the strongest evidence that we can have. And he didn't have a good explanation for why that wouldn't be good enough in court. He wasn't able to say, oh, I'm a triplet. They can't prove it's me. That would have actually been a reasonable response, but he had no rational or reasonable way to say that that wasn't strong evidence. The final piece, again, rational, factual, and then ability to consult with an attorney. So that third final piece is the ability to work with an attorney. You are not guaranteed, in our criminal legal system, you are not guaranteed a great relationship with your attorney. It has to be just passable. But are you able to provide information to your attorney about your case? Can your attorney give you information about potentially plea offers or what's going to happen? what their advice to you is, and do you understand that? Do you understand and take that in and make decisions based on what they're providing to you? It's really about this idea that, can you work with an advocate and understand their role and participate? The other piece of ability to consult for clinicians is also whether or not you can maintain courtroom decorum. Are you able to sit through a hearing, understand what's happening, pay attention, attend to what's going on, be able to simultaneously make a comment to your attorney if something's not accurate or something needs to be corrected? Are you able to behaviorally manage yourself so that the whole courtroom doesn't appear to be a sham? There really needs to be a sense that this process is fair and that someone watching would think that this person understands what's happening. Do they understand what's going on? So just some key things to think about as we keep talking about competency today. This is pre-trial. We're talking about competency to stand trial. And in our country, everyone is innocent until they're proven guilty. So as we're talking about this all day, I want us to continually remind ourselves that these are folks who have not been convicted. They have accusations against them, but nothing has been proven yet. They are pre-trial. Another thing I want to be really emphasize is that competency to stand trial is an unassailable right. So nothing can go forward if the person is not competent. Usually folks are found incompetent because they have severe psychiatric disorders, cognitive disorders, some sort of intellectual deficits. Things have become a little bit more complicated recently because we don't have a great system for thinking about folks with head injuries or folks on the autism spectrum. They don't fit so nicely into some of our legal boxes, and competency has become much more disputed in some of those cases. If you leave today with nothing else, this is what I want to leave with, is that competency to stand trial is separate and completely distinct from insanity. So the way that I always like to talk about it is that competency starts with a C, or we backwards, C. Competency starts with a C, and competency is current. Competency is now, current. So what we're looking for is whether or not they're able to do these things right now. Are they able to talk with their attorney in a reasonable way right now? Can they talk about the factual aspects of their case today, currently? Insanity is retrospective, in the past. Was the person mentally ill or have deficits at the time of their arrest? That's in the past. It's really common for folks to have a legal question about their sanity, about the time of the event, and then maybe they are having some symptoms of mental illness. They get treatment, they're returned to their baseline, and competency isn't questioned because currently, right now, they're okay. Competency, current, it's a C. Okay. Let's move on to these next ones. I'm trigger happy on my mouse today. So like I mentioned, competency is an unassailable right. So what does that mean? By ethics, a defense attorney, a prosecutor, or a judge, they all have to raise a concern about competency if it ever comes up. At any moment during pretrial conferences, during any hearings, during a trial, during jury deliberations, at any point, if any one of those folks has a concern about the defendant's ability to understand what's really happening, they have to raise it. They have to make a concern. Usually then the court orders a clinician to write an evaluation. So states vary in all of these ways about how these evaluations take place. It's usually in a jail or a hospital setting or in a community setting. And that evaluation involves reviewing records from usually the police reports, any mental health records that exist, any school records, anything that would be useful to describe the person's status. And then there's also often some testing and then a lot of clinical interviewing around those three factors, right? The rational, factual, and ability to work with their attorney. Evaluators are also checking for exaggeration or feigning. There's a sense that some folks believe that if they are looking more impaired than they truly are, then there would be a better legal outcome for them. So there's a need to just assess and view the potential for exaggeration. Just as a guideline, so you can have this in your head, as an evaluator, I generally will spend about 8 hours, soup to nuts, on an evaluation, on a pretty straightforward, average, typical evaluation. From reading the material, the police reports and other materials, to seeing the person, which is usually about an hour and a half for me, to writing all of the analysis and sending it off. It generally, I can sometimes be fast, but generally it's about 8 hours. Complicated cases where a co-occurring substance abuse disorder or cognitive deficits are playing into the analysis, it can take longer. Generally, these evaluations take place, are conducted by a psychiatrist or psychologist who has specific training in how to write reports for the court system. And this is what the first thing I wanted you to walk away with is competency is different than insanity. Competency is current. The second thing that I really want to emphasize today, and if you leave with nothing else, then I'm okay with you leaving, as this is your second reminder. A person can be mentally ill, and they can actually be quite mentally ill and be competent. A person can have an intellectual deficit and actually have a significant intellectual deficit and be competent to proceed with their legal system case. I was raised during the recovery model and that idea that your diagnosis is not your destiny. And I think as evaluators, it's really important to us that part of our job is that determining whether or not this person can proceed. Are they able to? And part of having a diagnosis not being your destiny is that full citizenship, right? Full personhood. And if you are part of the legal system and you have been accused of a crime, then part of full citizenship is being able to participate in that process. So I think sometimes we take a more paternalistic view, that's my word, paternalistic view, and say, oh, this person's mentally ill, they shouldn't be competent. But that's not what the question is. The question is this person able to do this case? Are they capable of doing what's expected of them in our community, in our society? And if the answer is yes, then they should move on. So I just want to keep that in your mind too, that there are folks who are being convicted and folks who are going through trial processes right now who do have significant mental illness, who are competent, but you can be competent and mentally ill. So the evaluation, the competency evaluation itself, the report, needs to answer two questions. One, does the person have a mental condition of any kind that leads to deficits, right? Do they have a mental illness? Do they have intellectual deficits or cognitive deficits that are relevant for their case? And then the follow-up is, yeah, if yes, does that make them incompetent? Are they not able to rationally or factually make decisions or understand their case? And are they unable to work with their attorney? Now, the follow-up question to that is about restoration, the restoration question. Can the person get better with treatment? Can something happen between now and their potential court case where they would improve and be competent? And that's what I'm going to have Dr. Callahan talk a lot more about after this. But I just want to, this is my crude chart that I always use. So this is not the flashiest chart you will see today, but this is how I have to think about competency. But again, the first question, is the person competent to stand trial? If the answer is yes, then they just proceed. And again, we say proceed with trial. I think we all know that most criminal cases are resolved. I think the percentage is 90% at this point of criminal cases are resolved with a plea bargain, not a trial. So we actually, the phrase we've been using is competency to proceed with their case. But if you're competent, you proceed. If you're not competent, then the question is, can the person get better? Now, in my jurisdiction, there's 12 months. That's the limit, 12 months to get better. Some states have 3 years. Some states have something in between. But generally, the question is, if there's treatment allowed, treatment is provided, can they be better? Can they be competent at that point? So people who maybe are not on medication and typically need medication, the answer would be yes, right? They can get better within that time period and they would be restorable. Some other folks, though, their condition is degenerative or is just long-standing. So if an IQ question, if there's a question of intellectual disability, typically the answer is going to be no. There's not anything that could be added or changed in the next couple of months, years, that would change how this person interacts with this information or their ability to rationally understand it. Similarly, I live in a state where there's a lot of aging population. So I see folks who have early stages of dementia. In a year from now, they're not going to be any better, and it's possible that they could be worse. So those folks, again, are considered not restorable. I see also a lot of car accidents, right? So a lot of drunk driving incidents where the person was is alleged to have been drinking or under the influence and then was in a serious car accident. And they also had injuries. They also maybe had a head injury because of this accident. So I'll see them maybe a month, 2 months after the accident. But we know that head injuries typically have a good year of recovery. Ideally, after 1 year, most of their recovery will occur. So it's hard to say how much recovery will someone get in a year. So you have to make this a clinical guess, a clinical estimate, hypothesis about what's likely to happen. What kind of strengths did that person have before the accident? What kinds of things could they have happen? What kind of treatment is available that they would be able to engage in the following months that could maybe improve their functioning, improve their cognitive ability, improve their rational understanding. So again, I want to just emphasize that not only is the question, is the person competent or not competent to proceed, but the restoration question. And that leads us to really this other portion of why we end up having people in jail and what we want to talk about today. So Dr. Callahan's going to talk more about competency and restoration and the problems we have in the system right now.
Okay, I'm so happy I remembered to unmute myself. Thank you very much, Shannon. Here's the prettier chart. I'm sure everyone on this webinar today is familiar with the sequential intercept model, and this is really where we like to start talking about the points really the inflection points across the criminal legal system where we can make or identify where some of the issues might be with regard to competence to stand trial and where some improvements can be made. I'm also going to offer some challenges to the communities that are on the webinar today, because what we've learned over the last number of years of working across a number of states as part of a couple of learning collaboratives that we have hosted at PRA via the Gain Center and working with a couple of states. Ashley mentioned the state of Washington. We've also worked with Pennsylvania and some other states. It's really hard to make changes in this and improve the process and the conditions under which people who are in this competence system, unless we look at the entire picture, because as we all know, you can make wonderful changes at intercept 1, but if the rest of the sequential intercept model, if the other systems aren't responding to that, a lot of your work really kind of falls flat or is very short-lived. So we pulled out Dr. Deb Pinos, who some of you, I'm sure, or all of you are very aware of her work. We do a lot of work together in this, and we pulled out intercept 2 and 3 and really did a deeper dive on what's going on in intercepts 2 and 3 for someone for whom competence has been raised, competence to stand trial has been raised. And I'm not sure how we can make this any bigger, but over here in the far left, it says diversion. Okay, that really should always be the first question. And I completely agree with Shannon that, you know, the question is, can the person, are they capable of standing trial, assisting their attorney, do they understand? But one of the questions I would also throw out there, and I can say this, I'm not a clinician, I can throw this out there, say, should we proceed, even if they are competent? Is this a case that's really worth the resources, diverting the resources away from this person while they're in the competence process, but also whether this case is worth pursuing? Because as we're starting to find in some of the states where some data are collected, which isn't very many and not very much, it's the same people often coming back over and over again, where they'll have multiple incidents of having competence raised. And so we're clearly missing something if we are unable to help them, support them, sustain their recovery and their treatment. So this is a way of really taking the sequential intercept model, and really you can apply this to your system. And the first question should always be, and all the arrows go back to diversion. You know, who's coming and going? You really need to be collecting data at each one of these points. What we've learned is not many data are being collected, and certainly not at all of these points. because it's very difficult to track where your barriers or where I refer, the system gets a little sluggish at certain points in time. And if you don't know who's coming in and who is really in charge of making the decisions about this, whether it's the judge or whether it's the evaluator or whether it's the director of the hospital, you know, we need to know who's in the system and who's making the decisions. Because if we want to make improvements, not just to the way the system works, but I would argue for the people who are in the system, we need to make sure that we know who's there and who's making the decisions. You know, why does it take so long to get someone from point A to point B? I mean, why does it take in some cases 360 days for someone to get an evaluation? It takes Shannon a day, 8 hours, sometimes longer, to do the evaluation. That's not in many cases where the problem is. It's somewhere else in the system. And so it's really important to take a look at your system to find out who's there and who's making the decisions and how much time it's taking. So I don't think there's a state in the country that would argue that their competence system is floating along just fine. We hear this all the time in the work that we're doing across the different states. And it is on overload, and it's shockingly on overload in some states. And there's a number of reasons for that. Some of them are individual decisions that are being made by whether it's the judge, the prosecutor, or the defense attorney. In most cases, anyone can raise the question of competence, and in most cases, the judges agree, and they will, in fact, order a competence evaluation. They're not in a position to make a call whether that's a good decision at that point. They'll make the decision, and essentially the person is out of sight, out of mind at that point in time to the legal actors, and that can really make for a lot of inertia in not moving the system along, not moving this person along. We've heard from defense attorneys who say that they often will ask for a competence evaluation for someone who's either clearly has some serious mental illness or has had in the past, because it helps them manage their caseload. So this has really nothing to do with the individual defendant. It has to do with managing the caseload. So there are many reasons and many ways in which the system gets on overload. Some of them are individual decisions that are being made, but there's also many of them, and we can we can address that in some respects with education, but there's also a lot going on in the system itself, which really makes it hard to make this a streamlined system where someone isn't spending more time than they should. Did I just do that? Where they should in the system. So we're going to talk about some of those, always keeping in mind that the people who are the most frequent users of this system or participants in this system, their lives are very complex. And I'm just going to give you a little snippet on that in a couple of slides here. So Washington State is the state where the True Blood class action suit occurred back in many years ago. I think 2015 is when it was initiated. It's been in litigation since. There have been settlement agreements, and recently there was a decision by the court, the same federal judge, that the state was in breach of the settlement agreement that had been reached in terms of providing diversion services to this True Blood class. And the True Blood class are individuals who were in jail in the state of Washington waiting for a bed at a state hospital for a competence evaluation. That's the real narrow definition of who the True Blood class is. And that's who all the decisions were made about them. Very complicated. I mean, there's other ways and places where people might be waiting, but that's really what the focus has been of the True Blood, all the True Blood decisions in the class action suit. These are the most recent data. And the reason I'm not picking on Washington, I'm presenting their data because they're one of the only states that has data that you can publicly access to know what's going on in the state. And so they keep this is available on their website. So any kind of data, anything you want to know throughout the course, the whole arc of the True Blood case, you can look at the data on their website. But this is just to give you really a snapshot of how many times in 1 month in the state of Washington, judges have ordered a competence evaluation for an individual. This is 1 month, okay? And keep in mind, it's going to take an evaluator at least 8 hours, if not longer, if it's a more complicated case, longer, to do all of these orders. So there's a workforce issue here too. I'm not going to go through all of these. I know these slides are available for you, but I wanted to really, so we get an idea of the scope. And Washington's not unusual in this. This isn't like an anomaly. These kind of patterns are reflected in other states as well that are reported to us. Their data are not publicly available. This motion for breach of the contempt settlement, the court monitor has data and describes that this is who is in the true blood class and as they're described here. And these are individuals that have a lot of serious mental health issues, physical health issues, often have a substance use, need substance use treatment too, have low likelihood of employment, often have had housing instability, if not having experienced homelessness over a course of years, and live in desperate poverty. So there's a lot. These are very complex cases, and this is who is typically coming into this class, if you will, of people who are incompetent or they're waiting to find out if they're incompetent to stand trial. And as the next bullets show, these are individuals who this is not the first time they've gone through this process. They've gone through it many times. They've received treatment and they've been discharged and gone back into the community and then have returned with the same question being raised about their ability to participate in their defense. What's really, I think, noteworthy and something I would encourage everyone out there who's looking for ways in which they can maybe change their system in some way to sort of slow down. I think of this as filling a bathtub with a fire hose. You just can't do it. I mean, you can't keep the overflow from happening. So in 2022 in the state of Washington, again, publicly available data, there were about 6,500 jail-based orders for competence evaluation. And only 40% of them were for people charged with felonies. So we can debate whether that is too many, too few, or whatever, but that's less than half of the orders. And this is where the question comes up, and some states are wrestling with, maybe we shouldn't be charging people with felony, or maybe we shouldn't be doing competence services for people who are charged with misdemeanors or maybe other less serious felonies. These are really important questions for the states to wrestle with, because it does mean you're changing your state law in most cases, certainly changing practice. You can change practice without changing the law. I mean, you can do that, and some communities are doing that. So let's talk about where restoration officially takes place. So these are not without controversy. I will say that up front, okay, and especially one in particular, which I will mention, that is controversial. The belief is that most restoration occurs in an inpatient setting. We don't have data on this, but I think we can, from fairly long-term observation, that's probably not true, because most people are waiting for a hospital bed. They're not in the hospital bed for restoration services. And in fact, in some work we did in another state, not in Washington, we found that over a third of people who were restored while waiting in jail, not in a program, but just receiving services. They were receiving medication, they had a bed, they had meals, they had medical treatment, and they became restored with no intentional restoration going on, a third of the individuals. So that's why I say probably. It certainly is the most common aspiration, is that people who are going to be evaluated for competence or become an inpatient for restoration. But there's a lot of restoration going on other places that aren't even counted. We don't count that. Okay, we do not count that in most situations. Now, hospitals are the default. Judges will say, we're going to order, Jane Doe or John Doe or whoever to the state hospital for evaluation and restoration if it's needed. And I mean, the hospitals are a good place to do that. I mean, they have a much wider range of clinical services than most other places, including medical care, and they have a higher level of security. And that's something that prosecutors and judges are concerned about. But again, go back, 60%, at least in Washington, are charged with misdemeanors. So is security really, the security level the same for someone charged with trespassing as it is for, let's say, murder? Probably not, probably the same security level, but we don't make any attempt at teasing that out or even creating policies that say, is this a security issue? Or is this something else? Is this someone who could be easily diverted into treatment and provided housing and supports and case management, et cetera? So it's, you know, hospital, very, very, lots of good services. The fact of the matter is they're not available to a lot of people and to most people who are in that 6,500 population who need these services. The cons of the downside of inpatient is the lack of bed capacity. There's not a state in the country that has the number of beds they think they need. It's very expensive to provide these services because of the comprehensive nature of them. And I would also argue the geographic isolation is a problem. It's a problem because of transportation. It's a problem because people become disconnected from whatever supports they had in their community. They're going to be disconnected from those because state hospitals are few and far between now, and they tend to be not in the most populated areas of a state. Now, this is the one that raises a lot of hackles, and I'm not endorsing it by talking about it, but it needs to be talked about. There are jail-based restoration programs, and these are intentional programs that are developed to provide competent services while the person is detained in a jail. Remember, not convicted, detained in the jail. So they're all pre-trial. So they're in the jail, and some are very casual, like low level, low threshold, like, well, they're here, we might as well do something with them. The other is, no, we're going to develop a program that goes through the curricula, that goes through the making sure that they can tick all of those boxes that Shannon talked about, that they really know what's going on and they can help their attorney in that process, and that they understand what's happening to them. There are many states have them, not all states have them. They're quicker. The person is there, so you can start services more quickly. Most people in the competence world pass through the jail, so you have immediate contact with them. It's in the community, so their community provider can provide inreach if it's permitted. So there are some pros to jail-based competence restoration. There are also a lot of cons, and it's a non-therapeutic setting. Jails were not created to provide treatment, and we could stop there. But the fact is that there are an awful lot of communities that are providing this anyway, whether they call it restoration or not. We know that there's a profound lack of treatment providers in the jails. We know that many jails are overcrowded, and the length of stay is unpredictable. So if you're talking about a program or a curriculum, the person providing the services isn't in charge of when the person's discharged. There's all sorts of other people who can discharge someone. And so you may be midway through the restoration program with someone and they're not there the next day when you go. These are just some information about jail-based restoration programs. And I feel like I need to say this over and over again, not endorsing it, just it's there. We have to describe it. It is there. And so there are lots of issues with jail-based restoration programs, and states are trying to, and communities are trying to work through these. And there's some pretty good research on it. And there certainly is more and more coming out about jail-based restoration programs if you're interested in learning more about them. One of the things that's important to consider about, or a number of things it's important to consider about the location is, I mean, here are a lot of questions you need to be asking. You know, you may not have any other options in your community other than to send them to or hope to send them to the state hospital. You may not have a wide medication treatment options in the jail, so it's just not even an option to provide that. So there's a lot of questions that you need to address before you can start thinking about alternatives to the state hospital. But while someone's waiting for the state hospital, what kind of treatment services are going to be provided to them? anyway while they're waiting to be transferred to the state hospital or to a private hospital that does restoration. Outpatient restoration is sort of an up and coming along with jail-based restoration. People talk a lot about outpatient restoration and not a lot of places are doing it. There may be programs, but they often are underutilized because going back to that, why the judges and the prosecutors like the hospital, it's a secure setting. So when we're talking about outpatient restoration, unless someone's in a residential program that's a little bit more secure, this is the level of security is much lower because it's in the community. But there's a lot of pros to this. And I would say the challenge is not only just standing up these programs, but also educating the full range of people who have an interest in this process to make sure that they understand that it's not just, you know, an hour's treatment a day and then they just disappear, that there is case management that goes with it. Sometimes ACT teams are attached to these programs. So I think it's worth investigating and learning more about these. The Washington, D.C. program has been researched quite extensively and they published on it. So they've got a lot of good information about that. They've been in our learning community for 4 or 5 years, can provide you with that information if you want. But I think one of the things that's really important about this is it provides, the person doesn't become disconnected from housing, from family, from treatment, from case management, et cetera. They're in their own community for the most part. And so it's more of a continuity of care than it is sort of separating them from what has gone before they were arrested and what's going to follow. So this is the question I would add to the ones that Shannon, okay, the person, it can be prosecuted, should we? I mean, maybe we shouldn't prosecute everyone who for whom competence is an issue. And the familiarity you all have with the SIM, I know, is quite deep and vast, but we like to look at it. What point in time might there be some options here? You know, what programs you may have some of these programs already in your community, and I would encourage you to look into it to find out if you do. So at Intercept 2, you know, we talk about quick fixes and longer term solutions. This is that initial detention and the court hearings. You can see the first one I put here. Limit competence to felonies. So it becomes a soapbox after a while. Making sure that you can train all of the people who are involved in this decision making. Remember those when I talked about the 2-3, who's making the decisions? They need to be aware of what the alternatives are. Educate them. They may already be there. Make sure that you can link these individuals to pretrial services that already exist. These individuals are pre-trial. Why are they sitting in our jails? Why are they sitting in our jails? And making sure that we can link people to services that are unique, perhaps, and again, Shannon referred to some of these. I would also add here, and I should have added here too, the VA offers a lot of services for people with head injury, with severe trauma, et cetera. So that's another really good resource for you if you have any quick access to a VA health center. There are longer term solutions, competence dockets. More and more communities are starting these almost ad hoc. A judge decides they don't want to lose track of everybody that they found incompetent to stand trial, so they start a docket and they keep track of them, and they make sure that they're well and that they have access to services and that they're supported. Making sure that you have evaluators available. Some states, like the state of Massachusetts, has an evaluator in court who can immediately do a really quick screen to see if this is a question that should even be raised. Should it go any further? And really holding to the time-sensitive processing of cases. The idea that someone charged with a low-level misdemeanor, to quote the judge in the True Blood case, who stole a cupcake, to be in jail for 360 days waiting for competent services is really not attending to constitutional rights, time-sensitive processing, et cetera. So here's some quick fixes to that stage that Shannon was talking about, that examination stage, the rapid access, transferring people to inpatient setting, competence courts and dockets, coordinating transportation. Sometimes that's the problem. They can't get anybody to transport someone in a rural area because there's 2 sheriff's deputies on duty and they can't transport them. There is a case which we didn't go into here, the Jackson versus Indiana, that kind of lays out the conditions under which you can keep someone detained for a long period of time who's incompetent to stand trial in that pre-trial setting. And it's only, it has to reflect the maximum sentence for their charge. So that's something a lot of states are probably perilously close to violating a Jackson timeline on a fairly regular basis, especially with people charged with misdemeanors. So what can you do with the Intercept 3? And I'm probably running out of time here. Quick fixes, and you'll all be able to have these slides. Standardize your restoration approaches, standardize and adhere to the statutory timeframes. There are, in many states, specific timeframes where you have to have the evaluation, that you have to have the report, that you have to have the start the restoration services. Do you know if your state is even following those? And do they need to be tweaked? Do you know, are people waiting in the beds because there's no place, they're restored, and this is something you hear more about than you'd like. They're restored and sitting in this really great high, intensity, high security bed because there's nowhere in the community for them to go back to. There's no housing, and so there needs to be a connection between these, not just the service providers, but the state and the community for that. Sharing information is important. Again, these are quick fixes, may not seem like it, but they're quicker than some of the others, like changing legislation. Longer term solutions, again, competence dockets, providing more coordination across. This is a local state issue. This is not just something the state can fix. The state gets sued, but the communities, the counties are the ones who are sending people into the competence system. There has to be coordination here. Let's see. So here's some, I'm almost done. Here's some policy questions to consider. I mentioned this earlier. Should you even charge this? I mean, maybe they're eligible for a different kind of diversion. If they weren't in the competence system and had these charges, would they be eligible for diversion? And if the answer is yes, then why does it matter that they have a mental illness? I mean, if they're eligible for diversion, divert them. I mean, get them out of the system. What I've mentioned to some public defenders is hit the stop button. Don't ask for a competence evaluation on everyone who you know has a mental illness. Stop and ask the question, should we even go forward here? How many evaluations are required? How frequently? They take a long time. These are really big investments. I mean, and it's we have a workforce crisis in this country, and we don't have enough evaluators to do all the evaluations that we are demanding be done. Again, what are the required timelines? Holding your communities to those timelines. And then the question that Shannon raised is, what if they're unrestorable? What programs do you have? Are they going to stay in the state hospital bed for the rest of their lives? So it's really important to think about that. And while it's not part of the insanity process, some people estimate that if you could move someone who was found not guilty by reason of insanity out of a hospital bed, that would free up 3 people of eligibility for a competence evaluation every year. So every year someone found NGRI is in the hospital, in a secure hospital, that's 3 evaluation cycles that could be done per year. So that's something else to think about. Some procedural questions, again, diversion, setting up programs, using programs that exist. Thinking about, and this is a challenge, again, not being a psychologist, I'm not challenging my own profession here. Do all evaluations have to be done by a clinical psychologist? I mean, our immediate gut reaction is yes, of course, but we might need to have a conversation about that because we don't have enough trained psychologists to do all the evaluations. And can they be handled by a team? Is there a special competence team that could manage people in the community? Are peers used in the process? Peers could be a great asset to assisting people, especially keeping people in recovery and keeping them in the community, making sure that they stay connected to services. Collect data on this process. Start somewhere. There's an amazing lack of data in this process. What options do you have? Talk with your, I mean, the judges are making the decisions. The judges need to be part of the way in which these systems are going to be changed. Okay, I'm not going to talk about that one. So I'm going to stop there because I'm over by probably about 6 minutes. And I'm going to turn this over to Dr. Demaray, who's going to talk about the research in this area. And then we can answer, there've been some questions there and we can circle back to those afterwards.
Thanks, Lisa and Shannon. So I think, frankly, we could summarize my whole section of the presentation by saying what Lisa just said. There's an incredible lack of data. And that's going to be sort of the takeaway that you're going to get from this research section. So just to sort of lay the foundation here, we've been talking a lot about requests for competence evaluation, system and community crises, system-wide efficiencies. We talk a lot about wait lists. And there are a lot of efforts nationwide to implement policies and strategies. I mean, that's what keeps us busy in our organization for a good portion of the time. So what I'm going to talk about is really just this need for empirical evidence to make sure these things are working. And the fact is that we don't know a lot about these innovations. And I saw, Reggie and some other questions in there, that there really aren't the data that we need, or that the right questions are being asked. So those questions in the comments today, in fact, are better than a lot of questions that we're seeing in the research. So let me tell you a little bit about that. I'm going to present a competence research framework that our colleague, Dr. Richard Van Doorn, developed when he was doing this, some of this work with the Gaines Center. So first, we can do research on kind of this idea of who gets in. So talk about population characteristics. What is the population of people who are being referred for evaluations? How do they compare to the local characteristics of either the mental health system population, the community population, et cetera? So really descriptive, really talking about, the prevalence of mental illness, sociodemographic characteristics, et cetera. That is what I would call, or he would call, stage one of this process. The second stage of research would be about who is found competent or incompetent, who is found restorable versus not, how these services are implemented there at the bottom of your screen. So what kind of services are being implemented to restore to competence? Where are they being implemented? How do they compare to other services that they might have been getting if this question hadn't been raised and these referrals hadn't been made? And then also a critical question on the left-hand side of your screen is, how are these services and these policies being implemented? So that's all about who and what is being done, but then we also want to ask questions about, is it working, right? And I think really, this is where the field is. We want to know, are these things that we're doing, are they working? One aspect of working is how the person receiving the services perceives these services. Are they satisfied? Are these services fair and equitable? Do they have the effectiveness that they're supposed to have? A related question, one that gets more attention, is who is returned to competence, right? How long is it taking? Are these individuals adherent to medications? Are they abstaining from substance use, et cetera? So these are what I would call the clinical legal questions or outcomes. And then finally, what I get asked a lot of, because of my work in violence risk assessment and risk assessment for public safety, questions about, well, what happens then? Are these individuals committing more crimes? Are they coming back to subsequent police involvement? Are they going into acute care settings, et cetera? So those longer term impacts. So in an ideal world, this is how we would do and approach the research on competence. We would actually look at all these different stages of research. I'm going to talk a little bit about what has actually been done. Oh, and sorry, before we do that, the last thing that I would say is that at this point in our evolution in research, we can't ask any of these questions without asking if all of this stuff is happening equitably across groups. Are there disparities? Are there other factors that are affecting the evidence and the effectiveness of these approaches? Okay, so what do we see happening? Basically, the research base that we have so far speaks to the stage one. The vast majority of the research lies there. I put those dashed lines around stage 2 related to what's happening, and I'll explain why in a minute. And then finally, this question of competence, are people being restored? So, there's a lot of research that ought to be done in this sort of ideal research framework, but in fact, we're really only touching a few pieces of it. And I'm going to summarize to the best of my ability the state of the field. Oops. I'm also trigger happy today. Okay, so the literature is vast. There are so many publications. I put 70+ publications since the 1960s. So remember, Shannon mentioned that really the laws that we use today went into effect about 60 years ago. And since then, I think we're closer to more about 80, and I'm talking primarily about peer-reviewed studies at this point. And then there's also about a dozen or so state level reports that have varying degrees of information and data, Washington State being a prime example of somebody sharing out public information, but there are, a handful of those that are out there. But again, the vast majority of the research really focuses on 3 things: the characteristics of the population, processes that are being used, and then a little bit on the outcome of restoration. So I'm going to start with this focus on stage 1, and I want to point you to this meta-analysis done in 2011 by Pirelli and colleagues, where they reviewed and synthesized findings of almost 70 studies that represented close to 30,000 individuals. And these studies have been conducted over the last 60 years. So what did they find? They found that the studies primarily looked at the sociodemographics, the criminal legal characteristics, and also performance on assessment tools. Now, remember for a moment that most of this work historically has been done by psychiatrists and psychologists. And I'm putting myself in that bucket because what do? Well, we develop and measure, right? So we speak to, and we also treat, but in this case, we develop assessment tools and measures. So this is where a lot of this research has been done. At a very high level across all of this research, the findings suggest that the vast majority of individuals who went through this process are men. This is not surprising, at about 80% or greater. And compared to competent defendants, they're less likely to be white, they're married or employed, they're more likely to have a psychotic disorder, they're less likely to have personality or substance use disorders, more likely to have a psychiatric or treatment history, less likely to have violent or criminal histories, and they performed more poorly on assessments, and especially on competency assessments. Now, I hope all of you had the same reaction as I did, because my next slide was going to say, so what? Because really, this is telling us what we already know. We spent, as a professional discipline, about 60 years doing research saying that, hey, these people that were referred for competency evaluations look incompetent. So it's not to disparage this body of work or the rigor with which the work has been done, but it doesn't provide any guidance regarding who can or cannot be restored to competence. It doesn't provide any guidance on how or where competence restoration takes place. So stage 1 in any research is really about characterizing the group of people we're interested in. And I think if I were to make a recommendation to the field, I would say, we've got it. We know who these people are. Now let's figure out what we should be doing. So there's really a need for empirical evidence on restoration itself. So that would come then when we're looking here to the what is being done and is it working, right? So thinking about stages 2 through 5. Well, to my knowledge, really all we have is research on the services and the outcome of competence, very little on these other things like treatment engagement and satisfaction, on longer term outcomes in this population. And to preempt Reggie's question later, really very little connection between other strategies and the degree to which they're impacting the prevalence of or the population of people found referred for competency. So this might be my favorite title I've ever seen. This was Pirelli again and colleagues that looked at trying to do another meta-analysis. So here they tried to review and synthesize findings of studies specifically focusing on restoration. So they identified ultimately 51 different studies or samples that represented about 13,000 people, and these were published between 1975 and 2013. Jumping ahead to the main outcome, they really found that there wasn't enough here, even despite the fact that this research has been going on for so long and that there was so much research being done, that there was just such glaring problems with the work that they couldn't say a whole lot about what was in it. So most studies don't actually report anything at all about the specific strategies that are being used. They say strategies are used, therapeutic interventions. Sometimes they use, and this is a direct quote, a combination of therapeutic interventions. My email box or my phone call rings when somebody wants to know, well, what should we be doing, right? And I'm sure that's what Shannon and Lisa hear too. You know, ultimately, I would tell you to do what's clinically indicated, which is such a cop-out because we don't have the empirical evidence specifically to say this on that, you know, that cumulative evidence base. There's a handful of studies that also say that they only used medication to try to get rid of the symptoms, so to try to treat those psychotic symptoms themselves. But again, then they're very non-specific even on the medication. And so we don't know much about what actual medication was used. The vast majority of the research is conducted in inpatient settings, vast majority, even though we know in reality, this is probably not actually what's taking place, just to echo Lisa's point. Finally, another question that I probably get even more often is, well, what about outpatient restoration compared to inpatient restoration? I have no idea because the research itself has not compared, to my knowledge, any outcomes between these different settings. There's been research doing it in one setting and the other, but no research that's been able to actually compare outcomes across settings. So what do we know from this research? One of the things that is promising, but again, remember, this is a very specific slice of the people who are being restored, is that about 4 out of 5 folks are restored in these studies. This is a higher rate than we see in many state reports. So I just want to call out here that this could very well reflect the research and not necessarily the state of the field. In terms of the length of stay, we see somewhere between 5 to 6 months based on the people in these studies. Now, remember that these are people that are in the hospital setting, the vast majority of them. So this may not reflect, and likely does not reflect, those long wait lists and that time that preempted and predated them actually being referred for treatment. And then you can see there too, just very consistent even with what Shannon was talking about, that the range is wide, anywhere from 6 weeks up to 3 years. So some of the issues, and I see a hand there, and I'm going to break for questions fairly soon, if you can hold that question. So some of the limitations are that the definitions across all these studies vary incredibly widely in terms of what a wait list is, in terms of what treatment is, et cetera, in terms of even what competence status means. The designs are not rigorous or, more importantly, suited to the research questions. There's pretty poor and inconsistent measurement of these different variables or constructs across studies. And frankly, there's just really insufficient information provided on what was both done in the research or evaluation and also what was actually done in clinical practice. And this is just a wonderful quote. So these authors of the most recent meta-analysis said, in short, the current state of the competence restoration literature is dismal. I should say that these two authors are also very well-respected colleagues in the field, and we're not calling out just their colleagues, but themselves as well. So my recommendations here really are to fund it and do it. We need a lot more research in this space. When there is a plan to implement a new strategy, a new policy, there needs to be a plan for how we evaluate it. We have to prioritize research specifically on restoration. I think we can be done talking about what the population looks like, and instead talk about what works and for whom, in what settings, and using what strategies. Just a couple other things that I want to say here. So again, we've been doing a lot of the research in the front end of this characteristics, and we really need to move into this idea of how is it working? I want to also call out that we really ought to be asking questions about how the individuals who are receiving the treatment experience this process. This whole process comes about because of our right to participate in trial in a meaningful way. This also speaks to our civil rights and the fact that we should be able to participate in treatment in a meaningful way and find treatment to be a process that is manageable, if not enjoyable. And then finally, I think any research in the criminal legal space these days really has to pay attention to, more so than ever, disparities and subgroup analyses. So these are technical recommendations. If there's anyone on the call who is engaging in research itself and thinking about how to either do evaluation or independent research in restoration, these are recommendations I borrowed and kind of added to from Pirelli and Zaff. So the first would be, there's going to be different definitions across states because of how different legislation looks across states. So my recommendation and our recommendation here is to use the legal definitions of those states. It's not going to be generalizable, but at least it's defensible and speaks to the question locally. Two types of research designs. We should either be comparing people who were restored versus those people who could not be restored in a retrospective way. There's been some really messy research comparing people who were restored to people who were fine all along and don't have any mental illness. Those are just apples and oranges. What we need to know is who can and can't be restored and why. Or we can do prospective analyses of people referred and see who is restored over time. We also have to be much more specific in identifying how people were identified, how people were assessed, what specific interventions were done, and then finally to do this and measure these things in validated and standardized manners. All right, so with that, I think that's the end of our presentation, and we can open it up for questions.
Amanda, if you're still able to unmute and speak, do we want to start with you? And then I know we have several questions in the chat box as well. All right, then, if you're figuring that out, Amanda, let's go to maybe the issue around folks with intellectual and developmental disabilities. And Lisa, I see you commented back in the chat, but do you want to talk a little bit about that? Open to any of our experts.
I will punt on that one because I know Shannon, oh, she disappeared. Her picture disappeared. Shannon raised that in terms of some of the, one of the issues that comes up with the evaluators. I know that I would just add that I know one of the strategies that's being used by some of the subject matter experts we work with is really to make it, it's really an ADA, an Americans with Disabilities Act issue in many cases. So I'm using that as a strategy in addition to the questioning the appropriateness of someone being in that process at all. But Shannon, did you go?
I'll jump in too if Shannon, maybe we need to sort of go back to her after. I think the other thing that we can talk a lot about in terms of IDD is thinking about the degree of the deficit. And again, this question of restorability. And so there can be differing degrees of deficits as with mental illness. And we can think about whether there are possible compensatory strategies to help support learning and to help support comprehension and participation. However, there might be a point in time at which we have to ask the question about restorability. And then also Lisa's question about whether or not there is really, is this the thing we ought to be doing? So it's a complicated question. And I think a lot more, we're seeing this filter into the competence arena and not having a whole lot of clear guidance, but those are strategies that we would use in other spaces when we were faced with individuals with IDD.
Thanks, Sarah. And if folks have further questions on any of those topics that we addressed, feel free to chat them. Referencing what you just said, Sarah, and I think it came up in all three of your presentations, this issue of sort of if they weren't in the competence system, would they be eligible for diversion? Lisa, I think you used that language. Could folks talk a little bit about how to raise that point across sites? That's certainly something that we've heard a lot in our technical assistance to sites, but that question of, especially for folks charged with lower level misdemeanors and potentially coming through the system over and over, what's the starting point as you see it?
I have an example I can give. Because it speaks to the question someone just put in the chat here too. How do you convince your criminal legal partners to join in and do this? Start somewhere. One community in particular started with people charged with trespass, and just said, okay, can we start there? And this was a big community, so they had a lot of them. And so I think if you believe you're going to have a lot of resistance from some of your criminal legal partners, but not others, start with something that you think is a really low hanging fruit. Something doesn't take a lot of convincing. Obviously, someone charged with trespass for the third time in the last 6 months does not need to go to the state hospital for security. They may need a level of treatment that's a high level of treatment, but that can be provided in a different setting. So I think that's that would be my advice, because it is a hard lift in many cases to convince. A question I often hear from prosecutors is, where are they going to live? I'm not going to divert someone who doesn't have somewhere to live. So partnering with some of your community providers, we were on a call with a group out of the city of Nashville last year, a couple of years ago, I guess it is now, and the main housing provider director was there. Happened to work at PRA in the past, so knew him by first name. And said the judge wanted to start a competence docket for starting small, 10 people. But she really wanted the people to be like co-located to the extent they could be, and wanted someplace to live. And I just, you never know what someone's going to say when you ask them. I said, would you be willing to co-locate 10 beds, 10 apartments for the competence docket that they could have the same case manager, they could be, et cetera. And the housing provider said, yeah, I can do that. So it doesn't have to be built, 100 people at once. It can starting small, because that then that becomes the norm. I mean, that becomes an expectation. They've done that, as you know, Ashley. They've done that in Spokane. They've started small, and they've been able to really expand their. To Reggie's question, they're working with their co-responders around diverting at 0-1 people, the True Blood. The class members away from the system altogether. So I would say start small and start with the easy ones. Don't start with the ones that are going to really challenge everybody.
I would add to that, I think in channeling Shannon here is to have a discussion about what the purpose of competence is. Competence is about participation in trial. Or in the case, because again, as Shannon said, not all cases, most cases aren't going to trial at this point. But you can have, someone who is unhoused and has serious mental illness and who is still competent. The question isn't about treatment in housing. I mean, that's the real world question, but that's not the legal question. And so maybe having a very frank conversation about what is the issue that is trying to be addressed. And is it this legal question of competence to stand trial, or is it a community-based question about treatment and services and housing? And I think it's, often what I see in communities that we're working in is it's the latter. Folks are really interested in ensuring that people have somewhere to sleep, that they have food, that they're functioning well. And you can have all of those things and still be incompetent to stand trial, and you can have none of those things and be competent to stand trial. So the question, I think, is often misplaced as a mechanism to services, when in fact those services there's a mismatch with the legal criteria and the legal questions. But I would echo too what Lisa said is starting small. And then also, I think, I often think data is the answer to really do a bit of a needs assessment in your community to see, well, what would be the kind of best case scenario if we implemented this kind of program, and what's our goal? And if our goal is about services, diversion is likely to be more successful than any competence work or intervention that we might do.
Excellent, thank you. Shannon, welcome back. No problem. I want to give a second for folks to unmute before we have a couple of other questions more from our team based on what we've seen with sites, but I want to give a second if folks need to raise their hand or unmute, please do so. Okay, then let's jump to Reggie. I don't know if you're able to speak, but I see your question around coordinating with probate or civil systems as part of diversion strategies. Do you want to talk a little bit about what you're getting at there?
Yeah, thanks, Ashley. So in some systems, the competence is obviously different than the civil process. But for some folks, and in some discussions that I've heard, there have been conversations about how do you coordinate without blurring the lines, right? To get people to the right services in more of a civil manner. For a lot of times it might be, assisted outpatient or AOT kinds of types of programs or ACT services instead of going into the competence route. It kind of dovetails for me with the whole deflection thing of just, if you know that the persons are frequently going to be, that their history is every time they're contacted, they are found, they go through the competence process, and a couple of weeks later, because now they're out, now they're back in again. So just deflect them. The other part of that is that clearly when we're deflecting them, we still need to get them the right services. And for some folks, some of that conversation is to do a civil process. But what I often see is that there are such kind of vast canyons between the civil process and the criminal justice process.
I don't have a good fully formed answer to you, Reggie, yet, but I have a couple of just thoughts and comments. One is, I think in a lot of places, the civil system and the criminal legal system are so siloed. I mean, they're not even they're separate attorneys, separate judges, separate buildings. So sometimes they can be happening simultaneously and the other one doesn't know about the other. So I think that's part of the issue, is that we don't have good connections between the processes that are happening simultaneously. So one thing that's been going on in my jurisdiction and here in New Hampshire is that there's been discussion about whether or not one judge can order competency, trial competency in the civil court. Like if there's already something happening in civil court and they're aware of charges, can we just do it all at the same time? Can we just get one order so that treatment can proceed, and that the civil commitment can also include restoration services? And then you also said something else that I think is really, really important, is that folks who, I think this is what you're referencing, so correct me if I'm getting it wrong, but where folks are getting arrested and then they're in the wait list for competency evaluation or in a wait list for competency restoration, and then they get arrested again, and then they get arrested again, and then they get arrested again. And there's really no state that has good statutes about timelines, or, if you've been arrested within 6 months, then everything will be lumped together into one process. There's not clean or neat or organized ways to do that. And instead of courts often saying, gosh, this seems to be an issue, like competency keeps getting raised for this one person, I think the view has been courts saying, gosh, they still keep getting arrested. So clearly we need to keep pushing and keep going down the criminal legal system route instead of the treatment route. The response is really, even if it's things like repeated, squatting isn't the legal term, but here in the winter, we'll see a lot of folks who are unhoused, who are repeatedly found in places that are illegal, and they'll be rearrested and rearrested and rearrested. So suddenly they have 14 charges. And the courts really look at that as, well, this is a menace that we need to really become strict with. There's not this view of, oh, the repeated competency process isn't helping, isn't getting them into treatment, isn't working here. And those are those kind of higher level legislative, state versus community, education for the police issues that really have been the problem with moving forward and improving our competency system.
Thanks, Shannon. I appreciate that. Yes.
Connie, I see your hand. Are you able to unmute and ask a question?
I am.
Great.
Hi, hold on. So just a quick question. I'm Connie Almeida, and I'm the Director of Behavioral Health for Fort Bend County. We're in Texas. So one of the things that I've learned after years of being in this field is the variability in our systems, programs, definitions, and it indeed makes it a challenge for us. So this was an excellent presentation, great reminders, the need for data, research, all that. But I wanted to ask for you to elaborate and maybe just kind of further thoughts on one of the issues that you brought up, because that's actually been our experience, is that actually a lot of the people get restored, and I'm using that very loosely, by getting them on medication, some additional services. We actually had a very successful case where I asked the court to just put the whole competency issue on hold, defer it, got her connected into treatment, outside provider stabilized, and doing great. But it concerns me because if those individuals do not get those additional services, right, which they should be getting anyway. I mean, we should be doing everything possible to engage people in treatment and getting them on the appropriate medications. But if they don't, they can remain on those long waiting lists for very specialized, very costly beds. Or even for the formal competency to restoration programs. And I guess in my experience is that there's also variability in those programs. So I don't know, can you talk about that? Like, how do we do that? How do we, do we create like competency restoration programs that are recognized by the courts in the system? Because that's really what we're talking about when we're talking about, connecting people to needed services, either in the community or in the jail, and not the formal programs. I'm not saying that we don't need those formal programs, but again, what you have all mentioned in my experience is there are a large number of individuals that basically just need to get connected and engaged with appropriate services, including appropriate meds. Easy question. So.
I don't have a good answer to your question. I think my answer would be that we need to, or wouldn't it be great if we could all, as a nation get on board with emphasizing deflection and diversion early in the intercepts, because to my knowledge, I don't know of any research specifically comparing long-term illness trajectories or quality of life outcomes in folks who went through, say, competence restoration versus other services. And again, returning to the legal question of competence, you can return somebody and restore somebody and them still be quite ill and have all the issues that led them to be ill in the first place, because the restoration process is focused on getting folks, from a legal point of view, I think generally most folks want to be more holistic, but truly the question is about getting them through their trial or their case. And I would suspect that if we were to do, and to Reggie's earlier question, more early diversion and deflection with things like ACT, which are also used for restoration, but that we would probably have much better outcomes overall. So it's really about an investment. Now, the nice thing about competence is it provides a statute, legislative kind of reasoning and justification for funding services that I hope all of us on this call would agree should be funded, but it's funded for a legal reason as opposed to funded for it's like what people need and it's the right thing to do reason. So I don't know if there's a better sort of answer in terms of your question of what we ought to do, but I really think that there's got to be more work, or I'd love to see more research linking the effectiveness of those services in preventing getting to this sort of place of waitlist crises that we're seeing.
I'll add to that I think, again, I don't have data. This is anecdotally from me, that I think the rise of crisis services has been key. Because if you have folks arriving to a crisis situation who can address the mental health or behavioral issues that are occurring right then we don't even start the process, right? There's no charges. There's nothing to be evaluated for competency because there's no charges. And I think so often we see folks who, I think of the families. So the family doesn't know what to do, or the homeless shelter doesn't know what to do. So they call the police, but that's not really what they want, right? They don't want charges. They just need help. And then all of a sudden there's this legal process going, and that train is out of the station and it's running, and there's no way to stop it. Even when the family's saying, I don't want to press charges, but it's already going. And then I see families say that they feel like, okay, the process has started. This person got an evaluation and then nothing came of it. So then they were still cheated. So what they wanted from that moment that they called for help never occurred. So I feel like as soon as we get someone on site right away that can really navigate what's needed, then we're just diverting correctly. We're appropriately getting people from even starting in the system.
Thanks, Sarah and Shannon. I would like to take just a couple of minutes that we have left, seeing no more questions, to mention that we'll have several resources related to this topic, in addition to the slides and webinar recording. And we'll have those posted to the SJC Exchange, the learning community website. If you are not a member of that community, or you're visiting here from outside SJC, my email is in the chat box. So feel free to just send me an email and we'll make sure you get all those resources. One of which I'd like to mention in particular is work that PRA has done through SAMHSA's Gain Center. And that is sort of an issue brief that has takeaways from several years of work that we've done with 14 states around competency evaluation and restoration. And that's a really nice sort of summary of the work. And then we'll also have a longer sort of comprehensive report on all of the work that will be released publicly this fall. So stay on the alert for that. If you'd like to sign up for SAMHSA's Gain Center listserv, I'm sure we'll post it there or again on the exchange. So some upcoming resources and some available resources. Now we also have some resources on the PRA's website. We have a microsite around competency, including the map that Lisa showed with the sort of layout across intercepts 2 and 3. So I want to give a huge thank you to our in-house experts for today's presentations and for the comprehensiveness of the material. And again, we'll get that sent out to everyone. Thanks for your questions, and seeing no more, I will give you an extra minute back on your schedules. So thanks, folks, and have a great afternoon.